But I think locally we wanted, Mr Speaker, thank the House for the time.
Charles Chevelle.
Thank you, Mr Speaker, as the previous person on his feet indicated, these statutes amendment bills have a special place in the standing orders of the House. They are an annual exercise. They are reserved for non-controversial technical amendments as to which there must be unanimity in the House before they can proceed. And Standing Order 3012 provides that if any member of the House objects to any clause in any one of these types of bills, then the clause cannot proceed. That's why the Associate Minister of Justice, Mr Borrows, consults over each of these provisions in advance with all the political parties represented in the House to try to ascertain which proposals from ministers for these types of technical and non-controversial amendments can go through on that basis. And typically what happens is the relevant spokespeople will get a folder of those proposals from Mr Borrows' office and be asked to consult with their spokespeople inside their parties as to whether or not the amendments truly are technical and non-controversial. I think it's fair to say that the majority of proposals are approved, but obviously if any member takes objection on the basis that there are policy considerations that ought to be more fully debated by the House, then the proposal comes out. Now, there are other ways that other parliaments deal with these types of amendments. In the Commonwealth Parliament in Australia, they have a main committee which has the powers of the House, but which effectively sits separately from the House in order to deal with non-controversial legislation. I think that's an innovation that's been considered here, but not yet adopted. It seems, at least to date, that we've been able to deal with these sorts of things through this procedure. Sir, I do just want to do something that I thought the Minister might have done, and that is briefly mention each of the pieces of legislation that are to be amended by this Act. I think it is as well for there to be some record in Hansard of what the House actually proposes to do today. So there are 16 statutes that this bill would amend. First of all, the Anti-Money Laundering and Counterfeiting Financing of Terrorism Act 2009. Section 38 of that legislation, which is the Act that implements our international obligations to ensure that in our banking and financial system there are safeguards around money laundering and the use of bank deposits and other financial instruments for the purposes of terrorism. Section 38 would be amended to make it clear that both the customer and his or her representative, if any, must have their identity verified to set up an unnamed account or other facility. And the regulation-making power in the Act would be consequentially amended so that the ability to declare an entity or class of entities to be a designated business group for the purpose of the Act does not require specifying the composition of the business group. So a good example of why this sort of thing can be dealt with in this type of legislation, entirely non-controversial and sensible, and giving better effect to the legislation itself, given some 3 years of experience with the legislation working in practice. The next Act that the bill would amend is the Children, Young Persons and Their Families Act 1989. There's a protective provision proposed to be inserted where custody orders that are currently made under that Act expire automatically when a child reaches the age of 17. This provision would extend that out to the age of 18 by way of an automatic expiry, so there's a protection effectively conferred for those who are aged 17 and subject to such an order. Again, that was clearly seen as something non-controversial and sensible by way of better making that legislation work. And it is interesting to note, sir, that the Government Administration Committee clarified when it dealt with the Statutes Amendment Bill that such orders will expire at the age of 18 unless they're specified to expire earlier. So there was that clarification added by the committee, and I believe that's going to be approved by the House. The next piece of legislation amendment is the Dumping and Countervailing Duties Act 1988. There's a provision for the refund of excess anti-dumping duty paid. That's obviously a sensible provision. If somebody is subject to a penalty under the anti-dumping legislation, which again is legislation that implements our international obligations in the trade context, then there obviously ought to be a power to refund an improperly levied duty. Then the Electricity Industry Act 2010 is clarified to make it clear that it is on the recommendation of the Minister of Consumer Affairs that the Governor-General makes regulations under Section 111 of the Act, and that relates to who can be exempted by way of class from the dispute resolution system that's set up by that Act. It wasn't clear in the original legislation which particular minister, whether it was the Minister of Energy or somebody else, who ought to be advising the Governor-General about regulations creating exemptions. Then the Gas Act 1992 would be amended so that the definitions of distribution system and gas distributor would be changed so as to take account of bypass distribution networks, so that a person who's a distributor but also a retailer who provides line function services to itself effectively by that dual role that they play in the industry, and then sells those services as part of a bundled service supplied to a consumer, is actually brought within the definition of a gas distributor. Again, a sensible and technical amendment. The bill also provides for the enforcement of the dispute resolution scheme to continue even if a person formerly subject to the scheme leaves it. They nonetheless can be subject to the dispute resolution scheme. The Heavy Engineering Research Levy 1978 Act is amended to increase the maximum prescribed rates of research levy from $5 to $20 per tonne of goods, and from 5 cents per kilogram to 10 cents per kilogram of goods. That's a very sensible amendment, and it will have the effect of increasing funding for research and development, something that certainly members on this side of the House would like to see. The Lawyers and Conveyancers Act 2006. At the moment, there's only one Deputy Legal Complaints Review Officer in the complaints mechanism scheme that's set up by that Act. This amendment would allow for a second Deputy Legal Complaints Review Officer to be appointed. Obviously, that will assist to speed up resolution of complaints under the scheme by allowing the burden and workload to be shared. Again, an amendment to be supported. Then there are some local government amendments. 1, 2, 3, 4 in total. They in turn amend list tax areas for groups of territorial authorities to clarify that the Auckland Council is the distribution authority for its area in relation to Christchurch, removing the antiquated reference to the Banks Peninsula District Local Authority, which no longer exists. There are some consequential amendments overlooked in other legislation. And then there's some legislation relating to the Auckland Council specifically. It provides that the Auckland Council can't dispose of certain property before the close of 30 July 2012 with a current rating valuation of $250,000 or more. Current rating valuations replaced with the term current market value. The Real Estate Agents Act is amended so that those licensees who've had their licences cancelled voluntarily in the 5 years preceding the time of the application are not prohibited from being relicensed. The Residential Tenancies Act would be amended to basically provide that every registrar and deputy registrar of the District Court is also a registrar of the Tribunal, and there are some consequential amendments relating to that provision. The Social Security Act 1964 will have the definition of work test married rate amended. The Veterinarians Act 2005, Sir, finally, will extend the amendment will extend the expiry date of existing practising certificates for applicants for new practising certificates until the application for the new certificate is determined. Sensible amendment, Sir, and the government SOPs, one dividing the bill and the other amending the Geographic Board, which we've heard much about, the Ngāti Porou Claims Settlement Act, which is outdated now because of other legislation that's passed, ditto the Te Roroa Claims Settlement Act 2008. Sir, for the reasons I've outlined, these are technical, sensible amendments and they will have the support of the opposition.
The Honourable Leanne Dale-Seal.